Today's topic is related to bankruptcy. That's why I'm up here. But we're going to talk about, I think, an interesting intersection between social movements and bankruptcy that I think we haven't seen a lot in the past. Just as I'm going to frame it and then turn it over to the panel, but if you think in the past that great social cataclysms have shown up in bankruptcy before, usually we call them mass torts. And so you can go back to 1982 with asbestos the first major bankruptcy by Johns Manville. And of course, we've had many other asbestos cases. We've had the Dalcon Shield case, the IUD case with the bankruptcy of A.H. Robbins in '85. Fast forward another 10 years, you have the silicone gel breast implants bankruptcy of Dow Corning in '95. So mass torts, which are social cataclysms, which impact broad swaths of society, have shown up in bankruptcy time and time again. And Judge Drainer and I have talked about movies have been made about the fact that these class actions end up in bankruptcy with a discharge. I think it's less common to see what I might call a social movement in bankruptcy, a social movement that imposes economic pressure on major institutions, and that economic pressure sometimes leads to change, but sometimes leads to insolvency and failure. I guess that maybe the one famous example that's still ongoing, and it began roughly about a decade or so ago, would be the Catholic diocese cases. Beginning in 2004, the Catholic Church being held accountable or responsible for failure to monitor sexual abuse by members of the church. And so you had the diocesan bankruptcies of Portland, San Diego, Minneapolis, St. Paul, even orders like the Christian Brothers and the Oregon province of the Jesuits. But I think that even those, you could call them as part of a social movement, but I think today we have, in some sense, some two very powerful and long-standing social movements that have sort of manifested themselves in bankruptcy in part. And those are the social movement represented by gun control, long-standing effort to control the use of firearms in our society, and also the movement addressing sexual harassment in the workplace and in society generally, and now given a powerful new life by the Me Too movement. And so what I wanted to do today is to talk about these two social movements which manifested themselves in cases you all know about, the Weinstein Company and Remington. So what we're going to do today is ask three questions. What's the state of these social movements? How have the movements been affected, or how do they lead to, and how were they affected by the bankruptcy filings in Weinstein and Remington? And what happened in those cases, and what can we expect going forward? So what I love about this topic is that it's impossible for just about anyone to talk about this topic by themselves. It requires a broad set of skills, and that's why on the panel today we have very diverse backgrounds, and I don't think any one of us could talk about this topic alone. And so let me just introduce the panelists. I guess I'll go from my far left and move to, your far right to your left. I'll start with Carrie Bettinger-López down at the end of the panel. Carrie is a 2003 graduate of the law school and currently professor of clinical education, professor of clinical legal education, and director of the Human Rights Clinic at the University of Miami School of Law. She's a long experience related to sexual harassment and violence against women. She was White House advisor on violence against women during the Obama administration. She was also deputy director of the Human Rights Institute and acting director of the Human Rights Clinic here at the law school before she went to the White House and then to the University of Miami. Next to Carrie is Sarah Steinfield, a 2012 graduate of the law school and an associate at Koskoff and Beater. I hope I pronounced that correctly. Which is representing the Sandy Hook families in the litigation against Remington. She has worked on a variety of med mal, personal injury, and civil rights cases, and barely made it today from work in West Virginia. Next to Sarah is Paul Leake. He's a 1988 graduate of the law school and currently partner and global co-head of the corporate restructuring practice at Skadden. He is a longtime actor in the space of corporate restructuring. He was a partner at Weil Gotshal, then a partner at Jones Day, before now being at Skadden. And of course, in that time, has dealt with a lot of notable cases that you've all heard about. Enron, Molycorp, and his clients have included many that you've heard about, including Aurora and Goldman Sachs. Finally, to my immediate left, I guess your far left too, is Judge Robert Drain, a 1984 graduate of the law school and currently bankruptcy judge for the Southern District of New York, where he has held the position of judge since 2002. Before joining the bench, Judge Drain was a partner at Paul Weiss, and of course, in his role as judge over the past 16 years, you can imagine he's seen some pretty major bankruptcies. But the one that I want to just point out that is highly relevant to today is that he presided over the bankruptcy of the Christian Brothers. Okay, so with that, I think you can see that we got a really neat panel with diverse experience. And I think just that, like I said, the plan of attack is to kind of set the lay of the land of these social movements, take us through the bankruptcy, and then talk about what's next. And I think that the best way to kind of set the lay of the land is to turn it over to Carrie and Sarah to talk about the lay of the land. And maybe, why don't we start with gun control, Sarah, and then Carrie, you can talk to us about Me Too. I guess talk about the Sandy Hook lawsuit in particular.
Certainly. I'm not sure if this is on.
I think it was already on.
Oh, good. Perfect. Nice to meet you. I'm Sarah Steinfield. As I said, I work at a law firm, a plaintiff's law firm in Bridgeport, and we're representing the 10 of the Sandy Hook families whose children were injured in the shooting in 2012. But I want to start out talking about a specific aspect of the gun control movement. I want to talk about one gun and one statute. The AR-15 is a weapon that was specifically designed in World War II around that time for military uses. It's a weapon that was specifically designed to have a very high velocity capacity. So that means that when bullets are fired out of the AR-15, it causes extreme destruction as compared to a lot of other weapons. It has a rapid loading magazine, so it's easy to switch out magazines and fire the gun for longer periods of time. And it has limited recoil. So that just means that this is a gun that is easy for non-experts to use. You don't have to be an expert at aiming. You don't have to be extra careful at hitting your target. And this was specifically designed for military uses because it's particularly effective on the battlefield. Now, fast forward years after World War II, and this was a weapon that began being marketed to civilians. In the battlefield, it was used as the M16. They basically made it semi-automatic as opposed to an automatic weapon and started marketing it to civilians. Now, this is where we come in. Bear with me a moment. Can you see this?
Yes.
Excellent. So Remington began marketing essentially the semi-automatic version of an M16. And this is one of the ads that Remington puts out. And I hate to be a cultural critic. I'm a lawyer, not a cultural critic. But essentially what they started doing was marketing this weapon to civilians without military training, obviously. There were no regulations in place the way that there are in a military environment or in a police environment that would regulate the storage, would regulate the usage, would regulate the training required to use these weapons. This is a gun that you could go out to any gun store and buy. Anybody could buy this. And meanwhile, they're specifically marketing these military uses, these assaultive uses of this gun to a civilian audience. Now, I'm sure a lot of you have heard about a lot of the mass shootings that have been in the news. This weapon is used frequently by mass shooters. So it was used in the Newtown event in December 2012, where 26 people were killed, 25 children. It was used in San Bernardino. It was used in the Pulse nightclub shootings. It was used in Las Vegas. And more recently, it was used in Parkland. And this isn't an accident. This gun is particularly useful for civilian mass shooting incidents for all the reasons that I described. You can harm a large number of people very, very quickly, and the harm is catastrophic. So let me move back a little bit. I'm going to bring you back to 2005. Around this time, a number of municipalities, Bridgeport, New York City, were recognizing the marketing that was happening and the fact that these guns were being used to, really causing a lot of damage in cities across the country. And there was litigation happening all across the country against a number of these firearms manufacturers. And around 2004, 2005, the NRA and a lot of these firearms manufacturers started lobbying Congress for protection against these lawsuits. And the result of that was a statute called the Protection of Lawful Commerce in Arms Act, and that was passed in 2005. And this is a very wide-reaching immunity statute for gun sellers and manufacturers. And essentially the idea of it is that the folks that are supporting PLACA don't want law-abiding gun stores and gun manufacturers to be responsible every time a criminal uses a weapon. But the statute is so far-reaching that it has an extreme chilling effect on all firearms litigation. It immunizes all sellers and manufacturers except for 6 stated exceptions in the statute. And those include the knowing transfer of firearms that if the seller or manufacturer knows that it's going to be used in a crime of violence or drug trafficking crime. A seller can be held liable, even in spite of PLACA, for a common law negligent entrustment claim or negligence per se claim. Knowing violation of a state or federal statute that is applicable to the sale or marketing of firearms. You can bring a personal injury claim for a design defect or a breach of contract or warranty. So those are the exceptions to PLACA, and those are very narrowly drawn in the statute. So when my firm was approached by these families of the Sandy Hook victims, we wanted to find a claim that would help them and would hold these gun manufacturers responsible for this deliberate marketing tactic. But we specifically had to figure out a way to get past PLACA, this vast immunity statute. And PLACA hadn't been, because it was such a new statute, there really was very little law interpreting it and figuring out what kind of claims could get past PLACA. So what we ended up doing is we tailored our complaint to bring 2 claims. We brought a Connecticut negligent entrustment claim and what's called a CUTPA claim, a Connecticut unfair trade practices claim. And I'm going to talk about that shortly. But in addition to the actual legal claims, we wanted to get the conversation going about the harms that Remington and other firearms manufacturers are doing by specifically marketing these weapons of war to civilian populations, and even more specifically to disenfranchised or young men who feel disenfranchised. So in 2016, as our litigation is ongoing, I'm sure everybody remembers the primary debates. Hillary Clinton actually began championing both our lawsuit as a cause, but also the repeal of PLACA, because PLACA inhibits valid claims from going forward. So I'm going to play you a brief clip of one of the debates where she discussed it.
I believe that the law that Senator Sanders voted for, that I voted against, giving this special protection to gun manufacturers and to dealers is an absolute abdication of responsibility on the part of those who voted for it. This is a unique gift given to only one industry in the world, by the United States Congress. As Senator Murphy from Connecticut said, we have tougher standards holding toy gun manufacturers and sellers to account than we do for real guns. And the point that Senator Sanders keeps making about how he wouldn't want a mom and pop store, that was not the point of this. And if he can point to any incident where that happened, I would love to hear about it. What was really going on, I'll tell you, because it has a lot to do with New York City. New York City was on the brink of being able to hold manufacturers and dealers accountable through a very carefully crafted legal strategy. The NRA came to their supporters in the Congress and said, stop it now, and Senator Sanders joined those.
Thank you, Secretary. Senator, go ahead.
So that was a big moment for our lawsuit, as you can imagine. And I want to go back a little bit and talk about the theories that we put forward, these negligent entrustment and cut-put theories. So as I said, these are two exceptions. Well, there are two exceptions that are drawn into PLACA. One names negligent entrustment specifically, and the reason that was put into the statute was really designed to target sellers who are selling to straw buyers. So people, if you have a felon who's trying to get a firearm and they come in with their friend, and the friend goes to the gun seller, and the felon is there standing in the corner winking, and the seller is selling it to the straw buyer in any event, that's essentially why that was drawn into the statute. Our theory is quite different than that. Negligent entrustment is specifically designed to get at sellers who, either with knowledge or reasonable knowledge, who entrust a chattel to somebody else knowing that there's a risk of harm, and when that risk actually comes to pass, those sellers or people those entrusters can be held liable. So when we drafted our complaint, we drafted that to essentially hold Remington liable for entrusting these weapons of war to a wholesaler, and holding that wholesaler liable for negligently entrusting the same weapon to a retailer, and also holding the retailer liable for entrusting the same weapon to the civilian market. And the idea is that the whole way along, they're making these deliberate marketing choices to land these weapons in the hands of, one, a civilian population that isn't trained and isn't regulated to handle these weapons safely, and two, even more specifically, they're specifically targeting young men, as I said, young men who feel disenfranchised. That they should have known, they had reason to know that this was a dangerous population to have these weapons, in part, although not exclusively, because the history of mass shootings that we've seen over the last few years. You know, this may have been a different issue 10, 15 years ago, but we're seeing these mass shootings almost on a weekly basis now. And even back in 2012, they were quite common. So knowing that, one, these are very dangerous weapons inherently, and two, they're specifically selected frequently to be used in mass shootings. So that's claim number one. Claim number two is an unfair trade practices claim. Connecticut has a very, very broad unfair trade practices statute. So I'm not going to spend quite as long talking about that, because I think although it's not unique to Connecticut, it may be somewhat less broadly applicable than the negligent entrustment claim. Those are our theories that we're putting forward. So I'm going to give you a very brief rundown of where things have gone with the case, and then I'll pass it along.
Okay.
At the trial court, we ended up losing on a motion to strike, which is Connecticut's equivalent of a motion to dismiss for failure to state a claim. And that was because the court ruled that that class of civilians that I was talking about as a dangerous group for whom to entrust these weapons to, that was too broad a class. The court found that because Congress has essentially ruled that civilians are capable and may legally own these weapons, that means that we can't hold them negligent. So in our view, the trial court conflated legality or illegality with negligence. So we're actually appealing this up to the Connecticut Supreme Court, and we've had arguments before them. We're waiting on a decision which could come down any day now. And the other issue, I did want to briefly discuss the cut-put claim. there's a very broadly drafted CUTPA standing statute, and the trial court found that in order to have standing under CUTPA, you need to have a commercial or business relationship between the plaintiff and the defendant. In this case, our plaintiffs are family members who didn't buy a gun, they didn't have any privity of contract with Remington or any of the gun sellers, so the court struck it on those grounds. We're appealing that as well because the plain language of the statute does not include that requirement, and there's very muddy appellate court law on the issue. So keep your eyes open. We're waiting on a decision. These folks will discuss the bankruptcy implications. In the interim, while the case was up on appeal after our arguments, Remington filed for bankruptcy. We were concerned that this could really affect the progress of the litigation, but as you'll hear, that hasn't borne out to be the case.
Thank you, Sarah. Carrie, you want to bring us up to date on the Me Too and the
Sure.
broader social movement regarding sexual harassment?
Sure. Let me just,
Yeah, sorry.
no, that's okay. Great. Okay. Thanks. That was great. Okay, so I'll bring us up to speed on Me Too. So, for anybody who's been living under a rock, there's a movement afoot in this country called the Me Too movement. We're all familiar with this, right? It began last October, really after the high-profile Hollywood actresses publicly accused Harvey Weinstein of sexual violence and retaliation against them. And Time magazine later named some of the Me Too victims the People of the Year, and called the Me Too movement one of the highest velocity shifts in our culture since the 1960s. Now, of course, the Me Too hashtag that was circulated by the actress Alyssa Milano, she wrote, "If all the women who have been sexually harassed or assaulted wrote Me Too on their social media accounts, we might give people a sense of the magnitude of the problem." And by the way, the Me Too hashtag, or the Me Too concept, for those of you who may not be familiar, was actually founded by a black activist named Tarana Burke from right here in Harlem. And she founded this over a decade ago to speak to the experiences of women and girls of color who had experienced sexual violence. And so Alyssa Milano took this concept and brought it into the mainstream, and it caught on like wildfire. So on your screen, you see some of the many tweets that came out over the next month. Millions upon millions of women and many men posted Me Too on their social media accounts, and many with very painful accompanying stories. And of course, that, let's see here. Come on. Okay. So that hashtag, of course, as I mentioned, came on the heels of multiple shocking allegations of sexual and intimate partner violence against women committed by high-profile men, from Harvey Weinstein to Bill O'Reilly and Roger Ailes to Bill Cosby, Ray Rice, and of course, our current president. Well, 3 to 5 million people, excuse me, let me go another direction. Okay, is this, would you mind if so 3 to 5 million people participated in women's marches in the United States in January of 2017, hundreds of thousands more worldwide. We have nearly 500,000 people who have signed the It's On Us campus pledge to end campus sexual assault. State and local governments and the Obama-Biden administration really took unprecedented action at the governmental level to ramp up prevention and response efforts. And many people argued, and I would agree, that Weinstein and the Me Too movement really mark a tipping point on both sexual assault and domestic violence in the United States. But where I want to ground this discussion is that Me Too didn't arise out of thin air. Catherine McKinnon, the legal scholar, who I actually had the great fortune of taking her class right across the hall when she was visiting here 15 years ago or so. She's, of course, one of our preeminent legal scholars and really coined the term sexual harassment. She talks, and she wrote a very powerful op-ed in the New York Times about how Me Too is really the zenith of a decades-old movement combating sexual harassment, but that movement was largely through the law. And so McKinnon argues that Me Too has been a turn away from expecting legal institutions to do all of the hard work, that instead victims are achieving the change that they seek through public shaming, through social media, through movement building, as well as through lawsuits, but that all of these things need to come together to create the moment that we're seeing. She argues that Me Too is eroding the biggest barriers to ending sexual harassment in law and in life. On the one hand, disbelief of victims, and on the other hand, trivializing, dehumanization of those victims. And we know that complaints are routinely passed off with some version of either she wasn't credible or she wanted it. And even if she was believed, the consequences for the oftentimes high profile and more powerful male perpetrator were often prioritized over the harm that was done to the victim. It could end his career. Look how terrible it would be for him, right? We see these tropes very often. McKinnon argues that it's widely thought that when something is legally prohibited, it more or less stops. And she says that's true for exceptional acts, but it's not true for the pervasive practices in our society that we see every day. Practices like sexual harassment, including rape, that are built into our structural social hierarchies. Unequal pay or racial discrimination are other examples of this, where they're nominally illegal, but practically very widely practiced. And only if victims challenge the status quo, she argues, of structural misogyny, and if powerful people are paying attention, is that going to change? And so I guess what I want to kind of bring to the table is that if we kind of take a focus on predators and think about kind of firing them one by one or criminalizing them one by one, that is not going to solve the problem. And so when Harvey Weinstein faces criminal charges here in New York, it's largely, that's likely, first of all, to be the exception rather than the rule, right? We know that prosecutors are loath to take on cases lacking in sufficient evidence to establish a case beyond a reasonable doubt. And we know that the nature of sexual misconduct allegations, as well as the legal definitions of sexual misconduct, assault, and harassment, may keep charges from being pressed in many cases. But when victims come forward, when they demand accountability in social media and then add lawsuits to the mix, then you think that you might have the possibility for real change. And so the culture around powerful Hollywood men or men in other industries is being shifted right now so that they are no longer protected, they are no longer enabled or even rewarded for their misbehavior. At least that's the direction that we're starting to see things, and the question is, will it continue? McKinnon argues that today's survivors are initiating consequences that none of them could have gotten through a lawsuit, right? So here's the critical point about kind of where the law comes in or doesn't. In part because of all of these legal limitations, but more because they are being believed and valued now in a way that they had not under a more procedural legal context. Women have been saying these things forever, she says, but it's the response to them that has changed. And men with power are refusing to be associated with that bad behavior. And that can fundamentally change our society, our workplaces, and our schools. It could restrain repeat predators, as well as the occasional and casual exploiters, right? These are the kind of two different profiles of male perpetration that we hear about. In a way that the law so far has not. And she argues, and this is a concept that my old boss, Joe Biden, used to talk a lot about, that this could change rape culture. I just want to take a moment just to talk about what I mean by rape culture, because that doesn't mean that this is a culture here in the United States where rape is the dominant social norm, but it does mean that we live in a society or an environment where our prevailing social attitudes have the effect of normalizing or trivializing sexual assault and abuse. So we can talk about victim-blaming behaviors, or sexual objectification of women, or trivializing rape, or denying widespread rape, or refusing to acknowledge that the harm caused by sexual violence can bring upon a person. So Me Too has come about, and it means different things to different people. It's been used in different communities, from Hollywood to the low-wage farm worker industry to other blue-collar jobs. Many activists and workers and victims are standing up. For some people, Me Too is about building awareness and empathy for victims. For others, it's about challenging policies or laws. For others, it's about offering better options for reporting. Challenging social norms is another purpose. Changes to the K through 12 context and re-examining masculinity. Those are all places in which Me Too has come about. So what's the connection to bankruptcy? And I'm just going to kind of make a couple of points here and then turn it over to my co-panelists to pick up on the bankruptcy part of things. So from Hollywood actresses to the blue-collar workers to the undocumented migrant farm workers, all of a sudden there is a voice for sexual assault victims in even unexpected places like a bankruptcy proceeding. And in a place where low-wage workers don't necessarily have a say and don't have any voice to participate in the proceedings, this is a really interesting and novel idea, and it's something that I've been quite taken by. Now, it doesn't mean that there's kind of some golden road here, and we're going to hear about many of the hurdles that victims face, in the Weinstein bankruptcy proceeding and otherwise, in terms of having a seat at the table and having their voices heard. But it's a really interesting avenue. In preparing for this, I learned that some scholars have proposed that standing in bankruptcy proceedings should be broadened to include various forms of non-pecuniary interests held by third parties, ranging from low-wage workers who might lose their jobs as a result of a bankruptcy, to victims who have a stake in the outcome of the bankruptcy or see the bankruptcy court as an additional venue to have their voice heard and to have their grievances recognized in law. And for me, as a human rights lawyer, that's extremely important, to give victims their so-called day in court. I think these are really interesting ideas and very reflective of our Me Too moment, and so I'm really looking forward to further discussing.
Thank you, Carrie. So we have these two social movements that have put enormous pressure, as we all know, on a variety of institutions, some of it financial, but on retailers, manufacturers, Hollywood, companies generally. And so what I want to turn now to think about is to turn to Paul and Judge Drain, is to think about how these pressures, particularly the financial pressure, played itself out in the two cases we want to talk about today, Weinstein and Remington. So the two questions are, to what extent did these social movements and the pressure they impose precipitate these bankruptcy filings, and how have the cases played out, particularly with respect to the treatment of the victims or the proponents of the social movements? Maybe, Paul, we start with you.
Sure, I'll go first. The first question, the threshold question, is what does this have to do with bankruptcy? And we all asked ourselves on the prep call. But by the end of it, we understood the theme, and it's kind of very interesting. So I thought it made sense to talk about what happened in the two cases we're talking about, the Weinstein case and the Remington case. Start with the conclusion and then kind of work back and give you some more facts, and we have the basis for our discussion. The conclusion in those cases as it relates to treatment of the contingent litigation claims we're talking about were as follows. In Remington, the company was reorganized, and what that means is the litigation claims are going to be determined in the ordinary course over time in the judicial system and through settlement, and will be paid by reorganized Remington, presumably $100 unless reorganized Remington fails in the future again. Contrast that with what's happening in the Weinstein case. In the Weinstein case, the company was not reorganized on a standalone basis. It was sold to a third party. And what happens in that context is these sales are done free and clear of claimed liens and encumbrances, including the litigation claims. So there's a pot that's created for the benefit of all creditors. And what's going to happen is those litigation claims will be, your litigation claims, will be determined over time in the same judicial process and settlement process, and then have access to what's left of the sale proceeds after paying priority claims. And based on the current view of the numbers, and I don't have any inside view of those, just looking at what's publicly available, it looks like there will certainly not be enough, because you're sharing at that point with general unsecured creditors and these litigation claims, pari passu against the residual in the sale proceeds, and the numbers look like they're going to be significantly less than 100 cents on the dollar. So two very different results for litigation claims.
Just to nail that down, it means that the Sandy Hook families, if they win, presumably they're going to get paid 100 cents in full, even though Remington went through bankruptcy and restructured its debts. Mm-hmm. The Weinstein victims, they will get a few cents on the dollar. So
yeah, I don't know about a few, but it's not 100 cents for sure.
They're not going to get paid in full.
Yes, not paid in full.
We can put it this way, that the company was sold for a certain price, leaving about $50 million, I think, for unsecured creditors, and trade debt alone accounts for 43 of that. So,
Correct. So very different recovery profiles, and the question is you have to ask yourself why, and then we're going to back now into a little bit more facts, so we're going to have the basis for a discussion, but hint, it has nothing to do with the different nature of the claims, the more sympathetic nature of one group claims versus others. It just has to do with dollars and cents. Let's talk about Remington, do it very quickly. As you heard, gun manufacturer. In the year preceding its Chapter 11 filing, it faced major decline, significant decline in revenues, and significant litigation arising out of the Sandy Hook litigation. And interestingly, in the papers, the debtors didn't put that down as the reason for their filing. You asked the question of what they say precipitated the filing. The interesting story was that in anticipation of Hillary Clinton.
It all goes back to Hillary Clinton.
Yeah, it does. In anticipation of her winning the election, they had a big inventory buildup, which hit their liquidity. Why the inventory buildup? Because the assumption was there would be stricter gun control laws post-election, and they assumed there were going to be a run on gun sales in anticipation of those stricter gun laws, and that didn't happen, obviously. And that left them with huge buildup of inventory, liquidity being hurt dramatically, already competitive pressures in the market. And so facing major liquidity concerns, and that's what they talked about when they went into court and talked to the judge about it. So they filed. What happened in the case? They very quickly talk about.
But can I just intervene
Sure.
real quick, Paul? I think that is there a story that nonetheless the social movement had some pressure because after Sandy Hook, Cerberus, the owner that had taken Remington through an LBO, tried to sell. A number of its investors didn't want ownership of this gun manufacturer, and Cerberus had a hard time selling it. It took on debt to pay off the investors who wanted to liquidate their rights, but banks were unwilling. I've only read this in the media, but my understanding is that banks were reluctant to finance a purchase of Remington because of the negative publicity of being associated with the sale of a gun manufacturer.
Yeah.
Could you argue that some of that background played into the Remington's situation, or just think that's more kind of?
I'm sure it had some influence for sure. The question ultimately is do you believe the story they told the judge? And ultimately, I'll tell you, as a practitioner, I tell the story that I believe is the truth, because the last thing you want to be caught on is a whole bunch of stuff for no reason, because it could have told that story as well. So what do I think caused their liquidity crisis that caused the filing? I think it was what they were emphasizing. Because we're going to come back to why do they take position and assume these liabilities? Ultimately, again, go to the bottom line, is somebody made a hard-nosed economic determination that those claims were going to be manageable. And a lot of people don't want to hear that, but someone made that determination and said we can pay those over time. To your point, so it may have had some influence, but what precipitated the filing was probably the liquidity crisis they were talking about.
Sure.
But I think that in terms of public perception, it's probably easier to forgive debt and take stock than to come up with new money to finance a company that is being hit in the media every day. So I think they might have been able to do it out of court with less pain, but we'll never know unless you were in the meetings.
Well, I'm going to simplify this because we're going to run out of time. So the bottom line of what happened in the case of 3 levels of secured debt, ultimately the first lien debt effectively rode through the bankruptcy. People in the case will shoot me for this description, but effectively rode through the bankruptcy. The second and third lien debt shared the equity, converted their debt to equity, and shared the ownership 80-20, and then reorganized on that basis. And the most important thing for purposes of our discussion was what happened to the unsecured creditors. And as I said earlier, the general unsecureds, including contingent litigation claims, rode through the bankruptcy. And you ask yourself why. We reached that conclusion earlier. It's basically that hardcore economic decision. Contrast that with what happened in Weinstein.
Can I just a quick intervention?
Yeah.
I know we're out of time, but from talking to people involved in the Remington case, I think what's interesting is that the understanding was that it would be World War III to try to restructure the claims of the Sandy Hook victims. So better to avoid that delay and the costs of trying to restructure that than to just have the bankruptcy case have no impact on those claims. Why is that better? Perhaps because of Paul saying that some may view that the probability of success may be low enough that Remington's creditors didn't worry as much about restructuring the claims of the Sandy Hook victims.
The case was done as a prepackaged bankruptcy case, and that means you cut your deal with the people that you think you have to cut your deal with. In this case, $1 billion of lenders in 3 different groups, and go into court with your votes already solicited, and you knowing that you have the requisite approval for purposes of going in front of the judge and asking for confirmation. And the case lasted 60 days, I think, from beginning to end.
Right.
And the savings in a case of 60 days versus a 9, 10 month, 11-month case is tens and tens of millions of dollars. And you balance that against that, plus not only those costs, impact to the business in the meantime, distraction of management of trying to make the business work long term. You weigh that against what you think the costs are going to be, and that's the hard-nosed economic analysis that's made. In Weinstein, do that very quickly as well. October 2017, a couple articles came out describing the allegations against Harvey Weinstein. It immediately impacted the business overnight. 25% of the employees were gone within a few months. Litigation commenced, defaults were called by lenders, and counterparties were trying to get out of their contracts with the company. The company had to react immediately. The first thing they tried to do was to sell the company out of court. They ended up with a deal, and again, simplifying this dramatically, they ended up with a soft deal, I'd call it, because it never got implemented, that contemplated a victim's fund of, rumor is, between $20 and $30 million. And over time, with an improvement on that bid, potentially as much as $80 to $90 million. Ultimately, that bid failed at a point where the company was out of resources to continue out of court to try to resurrect a different deal or fix that deal, and filed. And when it filed, it asked the bankruptcy judge to implement a auction, as we do very often in bankruptcy, to sell the company. And the result of that was a bid that was lower, but more importantly for purposes of our discussion, did not contemplate any victims fund. And again, you ask yourself, well, why did that happen? And there was a economic calculus done by the second bidder compared to what the first bidder probably went through. The first bidder said, I'm not going to run this through bankruptcy. I'm going to try to reorganize it out of court. And I understand the huge PR hit there is to this firm. So if I'm going to try to do it in this way, and I look at the value of the company and the price I'm going to have to pay for it, I take all those variables and say, I think I can commit 20, 30, and maybe more $1 million for any number of reasons to make this work for me. Fast forward several months later, with probably a lot of lost value in the company, terminated contracts, and the like, a economic dollars and cents decision made by that bidder at that time that the PR hit of not having a victims fund in terms of operating the business in the future was justified under their view of what they owed, their own responsibilities to their own constituents. And so very big difference in the outcome, having nothing to do with the sympathetic nature of the claims, but rather exactly how the different economic parties look at the dollars and cents of the deal.
So can I ask you, Judge Drain, what takeaways? I mean, one very dark takeaway from all this is that here are two institutions hit with potential liability and financial pressure by social movements. Both enter bankruptcy. In the case of Weinstein, victims are getting, the technical term is thwacked, and they're getting potentially very little. And in Remington, it looks rosy. It looks like the victims are not getting hurt. That's only because somebody made a calculation that they're probably not going to get much anyway. And so there's kind of a dark view of like that bankruptcy is kind of, in one sense, stripping away liabilities, and could have used it to strip away the liabilities of victims in Remington. It just so happens that in the case of Remington, the calculus meant that let's have a quicker bankruptcy instead.
Well, I could make it even darker, which is that if Sarah ends up winning and there's a large judgment, Remington could file again.
And then we get Weinstein.
It's important to note that in corporate bankruptcies, Congress has really restricted enormously what type of debt is not subject to the discharge. Individuals have a fair number of different types of debt they incur, including for willful misconduct, that is not subject to their discharge of their personal bankruptcy. So if Harvey Weinstein ever files bankruptcy, and he's found liable for sexual abuse, that would not be dischargeable. But in corporate bankruptcy, Congress has really limited it basically to certain types of securities claims and False Claims Act claims. So they've made that decision. Bankruptcy for corporations is much more of a collective proceeding, and Congress has set the priorities with secured debt first, administrative debt for the cost of running the company second, and then unsecured claims and stock claims below them. And that includes claims for torts as well as claims for borrowed money or trade debt. So that's the legislature's determination. Bankruptcy, there's a famous story among bankruptcy lawyers. A very nice district judge in Delaware, for a long story, ended up supervising a full bankruptcy case, very hotly contested case. The corporate lawyers, the bankruptcy lawyers were constantly in front of her. One day she'd had enough and she raised her hands and said, "I don't understand you people. All you ever talk about is money." And ultimately, that's what bankruptcy is about, with the priority scheme that the Congress sets. But because it's about money, these types of claims do have an influence. And I think it's clear to someone who's an outsider, like me, that the big change with the Me Too movement, in large part, is because of its financial impact, because it has a huge economic impact that hadn't existed before. So that does affect companies that want to survive. They have to deal with that issue. And as Paul said, in an out-of-bankruptcy context, the only way to deal with it is to put up a fund. Now, it appears from the press that, ironically, one of the reasons that deal didn't work is that former Attorney General Schneiderman opposed the deal and wanted more, not quite appreciating what the alternative was in bankruptcy. But if you're going to survive as a company and not really excise the cause of one of these problems, you're going to have to deal with the public perception, even if the victims themselves get pennies on the dollar. So there is an effect of these movements in reorganization cases where the business wants to continue. I would think that if Remington went the way of having to deal with the gun claims and survive in a subsequent bankruptcy, they might well decide at some point to get rid of the AR-15, for example. You know, I think its creditors would probably say, having turned to investment bankers who would do projections and say, you know, we've decided that all things considered, this company does better now not selling those things. You know, the asbestos companies challenged the asbestos claimants forever and sought ways to minimize those claims, but they stopped using asbestos. And diversified. So there are ways that victims, even though they're almost at the bottom of the priority chain, can have an effect in a bankruptcy case. One interesting point we discussed is the victims themselves sometimes have to make a choice. You know, do they want to use that leverage to kill the company because it's evil, or do they want to use it to maximize their recovery? And in the asbestos cases, it was a bit of a trade-off. The companies stopped using asbestos. Most of them had stopped already, or said they had. But the plaintiffs' lawyers, for their clients, wanted the maximum recovery, so they set up asbestos trusts. They didn't run the company; they were happy to take the money. You know, you can see. I would imagine if Sarah is able to win in her litigation, and Remington filed again, Some of her clients might want Remington to go away, to cease existing, even if they didn't get any recovery from it. Others would say, well, I'd like the money. I could use it for my family, or I could give it to charity. I could give it to NRA causes. There's a whole range of choices, and those types of choices play into the structure of some of these, how some bankruptcy cases are processed. It's very fact-based. As Professor Morrison said, I presided over one of the Catholic abuse cases, which were caused all over the country by, well-established claims that the diocese and other orders had not done enough to rein in and reveal the abuse by some of their priests and members. Those are not-for-profit companies. So the dynamic there is somewhat different than, a Remington or a Johns Manville. But it's interesting that in those cases, almost uniformly, for the first time, in the particular order or the particular diocese, part of the plan, the bankruptcy plan to get out of bankruptcy, was the first acknowledgement by the diocese, by the Christian Brothers in my case, that this had actually happened. They had been fighting it for 25 years on every possible grounds, starting with statutes of limitations, et cetera. No apology, no acknowledgement that this had happened. The claimants, the victims, were well represented by bankruptcy lawyers, but it was as meaningful to them that they got these apologies, which ultimately were heartfelt, and procedures put in place to deal with sexual abuse going forward that had not occurred. That was a major part of the settlement in my case and in many other cases, all of which were mediated. And I think the diocese, the Christian Brothers, survived in part because the victims didn't take everything. They were willing to accept the apology and take something as opposed to everything. So there's no real dark or light here. There's a continuum. It depends a lot on the facts, who the other parties were. In those cases, there were very few other creditors. But it amazingly, since bankruptcy is all about money, in those cases, for I think the first time, the church acknowledged this misconduct in a really meaningful way.
Paul wanted to say something. We started late, so I'm going to take us a little bit late. Feel free to step out if you really need to take a break. But I'm going to take a little bit longer. I'm going to let Paul chime in, and then we can take one or two questions too. So think about if you have a question. But go ahead, Paul.
Just two observations on what Judge Drain just said. First is what's interesting in the Remington case is that reorganized Remington is in much better position to pay much larger sums on account of this litigation as a result of the restructuring. It's now delevered by $750 million relative to a $1 billion capital structure prior to the Chapter 11 case, and it has excess cash flow in part as a result of that to do capital investment. So its business plan shows rising EBITDA, which it just allows them to have more ability to. So it's just the point of saying, not to say that, it'll never tip it into bankruptcy in the future, but they have a lot better position to pay these claims going forward. The second thing just goes to the heart of what we've been talking, we were trying to talk about really is like the social movement and what leverage does these social movements have in bankruptcy or over the threat of bankruptcy. And I think, what I got out of our conversations is that the main leverage is prior to bankruptcy. The best leverage is prior to bankruptcy. And where there's such a desire of the companies to avoid filing that they'll do more, especially on conduct changes in order to avoid Chapter 11. Once you're in Chapter 11, the calculus changes. There's only so many ways you can fix a company or reorganize a company. Two of the main ways are to sell the company and to reorganize it on a standalone basis, which simply means that people sitting at the table who are already captive agree on exactly what this company is going to look like on the other side and who's going to own it. When you sell the company, the ability to influence conduct on the other side once the claims are left behind is minimal to non-existent. And then more so, there is an ability to impact conduct. But as Judge Drain say, you might have to, as a litigant, decide: do I want to pursue my claims on a damages? In which case, even on a standalone reorg basis, they will be dealt with as dollars and cents and not more than that. Or do you want to compromise that in part in favor of trying to seek conduct amendments, or changes by the company going forward? Restructuring, the last point I'd make, restructuring is incredibly flexible. Under a plan, you can basically do anything that you can convince people to go along with, and that's consistent with some pretty basic rules of fairness in the bankruptcy code. And that's where you could see change, but careful what you ask for in terms of pushing and threatening to push into bankruptcy, because once you get there, your influence probably does decrease as a litigant.
Can I say one more thing on bankruptcy? Carolyn had mentioned standing in bankruptcy. The law is quite clear that the people who have standing to be heard in a bankruptcy case are the people who are directly affected by the bankruptcy, economically affected. That may well include unions and non-union employees, because they're going to have claims one way or another. But it does not include law professors who want to speak about these topics, or the NRA that wants to speak about these topics. And to my mind, that's a wonderful thing. I think that
He's a judge.
well, no, I mean, honestly, bankruptcy is not necessarily, it's not really a social movement. It deals with individual problems, and and that means that the people who really are affected have the voice, and I think that's the way it should be. So it has a societal effect, obviously, and certainly the Weinstein bankruptcy sent a message, at least through Hollywood, if not in other places too, that this is what happens to your company if you do this. But the individual cases, the actual people who are affected make the choice.
I'll take a quick question. Does anybody have a, yeah?
Hi, thank you so much to the panel. I just wanted to make one observation and see what you all thought about this, and that is, I believe that companies that sell or do a deal outside bankruptcy generally is a better outcome than if you actually go inside bankruptcy. And if that's the case, when the Weinstein company dropped 25%, there were still assets there. I mean, there were real assets to be sold there. Same thing with Remington. They made a bad business judgment. They thought Hillary was going to be president. They, bumped up their inventory, and they couldn't sell. But there was still assets there. And maybe there's banks were running away, but Cerebus is a very strong company, has a tremendous amount of influence in the market. To what extent does greed, denial, shame, pride, whatever it is, stop, I guess, Remington or the Weinstein Company from actually doing a deal before going into bankruptcy and having a pretty bad result?
Well, I mean, I think that I'll give you an example of uneconomic thinking based on public perception. I had a large case that involved the need to restructure union contracts, the Hostess Bakeries case. They had 13 unions, and some of those contracts really were way above market and were killing the company. Very sophisticated creditors like Cerberus. They went along with a plan that restructured those contracts in a way that was pretty favorable to the unions. After that plan would have been confirmed, the company would have been worth about $600 million. One union held out, and it was just too much economically. So then there was a liquidation. In the liquidation, the company was worth $1.1 billion. So socially, these sophisticated companies like Cerberus were willing to give up enormous value not to be seen as hurting the workers. And that's an effect. So it's hard to, I'm not sure someone who invests in the hedge fund would have thought that way necessarily, although maybe they were listening to their big investors. It wasn't Cerberus in that case. It was a number of other similar funds. But, that affects, I think that shows how value can really swing, not just based on the hard-nosed economic number crunching. Very few hedge funds come to a mediation with their recovery charts. There are a lot of other things that go into play.
But the cynical view is that those other things that come into play are part of the hard-nosed economic analysis.
Well, they are.
Yeah, that's the ultimate point from my perspective. The easy answer to your question is avarice, greed, everything, pride. It plays into every single deal I'm involved in. Yes, no doubt about it. The question is, do you get to something that maximizes value ultimately? And the question of maximizing value is a very complicated one. Do you maximize value, dollars and cents, to pay as much as possible to the lenders or even get more to the shareholders? Or what's the role of social responsibility that we were discussing just before the panel started? Does that maximize value? But also, as I said, I call it, what does it? I think that also, you can look at it as an economic decision as well. The company decides, I need to do X, Y, and Z as part of my perception. One, yes, no doubt about it, there are people who want to, quote unquote, do good. Absolutely. But flip side of it is that many people in the organization also say, I have other constituencies that I report to, and we should do this stuff if it ultimately is good for value. That's part.
I want to give Carrie and Sarah the last parting shot. We have a question in the back. Is it something that will go to Carrie and Sarah? Because we're out of time, and the last thing I want to do is cut into the dean's time. Okay, so So in the back, the green jacket with your hand up right now.
Right. It does relate to this. The problem with this panel thematically and relates is the relationship between social control and law. Many years ago, Donald Black wrote a book called Behavior of Law. Robert Edgerton refers to social control as the etiquette of the setting. I happen to like that. What the impact is on behavior of law ultimately is got to be joined with a thorough analysis of the force of social control about which you are discussing. So why are your forces of social control vastly different because social control and law are interlocked, as Donald Black said all those many years ago in his analysis. And his analysis points to the reason why your forms of social control related to Me Too and related to the victims of gun violence are different from the impact of the victims of police shootings and on the behavior of law, that is to say, the law enforcement of law enforcement. So my bottom line is here, to understand this, you can't operate from a standpoint of a legal analysis only. You need a social science approach to understanding that social control so that you can better analyze, in this panel or any other panel in the future, the relationship between social movements, social control, and likely or current impacts of law. Thank you.
Okay, so Carrie, Sarah, that was pretty open. I mean, we could spend an hour on that. So, but you only get 60 seconds. So each, I guess. But any parting thoughts about what we should think about going forward as we predict the path of these social movements?
Certainly, I will try to keep it to 60 seconds. Our process going forward, our best hope in the near term is winning at least some portion of our claim in the Supreme Court and getting back to the trial court and being able to do discovery. And I bring this up because I can't tell you what the outcome of our litigation is going to be. As I said, there are some complicated legal issues that are somewhat novel. But at least in the very short term, our hope is to learn more about the practices that Remington and the other companies have engaged in to out them, essentially. We have reason to think that they're doing even more than we already know to make intentional decisions about putting these weapons of war into unsafe hands. And when we're able to get that discovery, we hope to be able to publicize some of that, and that kind of goes into the social control, social movement issues. Regardless of the ultimate outcome of our litigation, we hope to be able to put some social pressure on Congress, on the market, and let people know what these companies are up to. And I also want to make a note that although I am a trial lawyer and I'm representing these Sandy Hook families, these particular clients are very civically engaged. They've started nonprofits. They're very interested in social change. So although we've brought legal claims, we also have brought claims for injunctive relief. So depending on the outcome of the case, we may be able to pursue that. And they're also interested in all of the public relations aspects of this as well.
Carrie, parting thought?
Okay, great. Well, yeah, I mean, I think I completely agree with you, and I think a lot of the conversation on this panel has really spoken to your point, that social control and law are interlocked, are mutually reinforcing, and it's very much an iterative and complex process about how they interact. I mean, just to think about, for example, sexual harassment law and the ways in which that might be changed by the Me Too movement. I mean, sexual harassment claims have always been hard to bring as a class, for example, because it's hard to prove commonality. But we might see that the Me Too movement is giving the potential for sexual harassment claims to be brought as a class in a Weinstein-type case, giving that more wind in the sails because people are seeing their commonalities as victims. People are, victims' voices are rising to the public discussion. And so, now maybe there would be enough victims, for example, to certify a class. And that's actually happening with Weinstein, right? We're seeing multiple class actions being certified. So that's not being certified, being filed. So that's one potential direction. The other very quick snippet I'll say, and this is something I've been involved with, is that I think the criminal justice system, for different system we're talking about here, but this is impacting them. When I was in the White House, the Department of Justice issued guidance on how police officers can better respond to domestic violence and sexual assault, free from gender bias. It contained a list of 8 very specific principles that police officers should be abiding by. And the state of Illinois, for example, has now passed a statewide act requiring training of every police officer in the state on gender bias in policing and having a much stricter reporting requirement. So we're seeing changes in laws and procedures as a result of victims' voices rising in a new way. And so again, social movements and law being mutually reinforcing and mutually informing, I think, is a major theme that we're seeing right now playing out in our everyday world.